Hello, everybody. I would like to welcome everybody to our today's webinar. Firstly, a very good evening, good morning, good afternoon, depending on what part of the world you're in. So, as you know, that today's webinar is going to be focused on ISO 27701 standard and how it can help you comply with the DPDP Act 2023. So before I hand over to our CEO and presenter, Mr. Ashwin, I would just like to tell you guys a few things. So the webinar will be for approximately 70 to 75 minutes. And in the end, we will have another 15 minutes for our Q&A and polls. So in total, it's going to be approximately for 1 hour. If you can see on your screen, there's a Q&A box. So if you guys have any questions, please post it in the Q&A box. And in the end, 15 minutes, our presenter will be answering all those questions. And simultaneously, we'll be running our polls, and we'll really appreciate if you all can participate. So that's it from my side. Now I'll hand over to Mr. Ashwin.
Yeah, thank you, everybody. Thank you for spending your time for this important act that we have. We have been waiting for it since many, many years, specifically all of us in the cybersecurity industry. We have been debating when it will come, when it will come. Finally, we have a good news. The act was swiftly passed in the accent in almost 1 week's time, and there we are with the act. We also had the latest good news from the ISRO. Everybody else knows yesterday. And so two good things happened in a very short span of time. That's great for our country. That's great for all of us. So I'll start with the important aspect. I'll start with my slides and I will go through them and, of course, discuss this important aspect on the Digital Personal Data Protection Act of 2023 and how the ISO IEC 27701 can help. So we are going to focus on some of these areas as mentioned. Just to be clear that this is a webinar which is focused on how to comply with the provisions from a technical and process standpoint. And we will not be discussing majority of the legal aspects, which I will leave it to my legal friends to take it up. We are primarily cybersecurity auditors, and we will focus more from an audit and compliance standpoint and what people from the compliance industry in terms of implementation of technical controls, processes, etc. need to do to comply with that act. Okay, so about SCDL, we are a cybersecurity firm based in Denver, Colorado, USA, and Mumbai, India. So we are a CPA firm, and we offer SOC 1, SOC 2 reports, and also we are an ISO IC certification body under IAS of US. We also one of the 15 only companies, 15, 20 odd companies empaneled by Cloud Security Alliance as CSA star auditors. We also do technical audits, vulnerability assessments, pen tests, and we offer training services. We have an AWS training, cloud training partner. We also empaneled by certain for doing audits for India customers. So I just wanted to clarify that SCDL is a cybersecurity audit firm. Getting reports such as SOC 2, ISO are byproducts. Many others in the industry are certification firms where cybersecurity is a byproduct. I will emphasize on this why I made this statement later on when we walk through this and tell you the issues faced specifically in the privacy industry per se, because privacy is not an easy subject. And we will, across this slides today, I will explain to you why. About me and my expertise in privacy. So my LinkedIn profile is open and I accept all connections from the security industry. Coming to my qualification, I've been a CPA and MBA, and I have many of the cybersecurity qualifications relevant to privacy is CDPSE, which is ISACA's privacy certification. I've been working in the privacy domain since 2010 or even before, when the AICPA introduced its generally accepted privacy principles in the year 2008. My privacy articles have been published in ISACA since 2012. In the ISACA Journal, I've been a reviewer on privacy articles, and I was also a speaker at the NA North American CACS, which is the ISACA's premier annual event. And I was speaker on the privacy governance when ISACA launched its privacy certification. So I'm not new to privacy. I've been auditing Fortune 100 companies on privacy, covering many areas. I've done SOC 2 for privacy, several of them. We have done HIPAA, we have done GDPR, we have done several of those privacy compliances. So I'm not new, and I mean we understand privacy in the depth of it. So the context is what the government of India states is both data and information will have big economic power, and we need to prepare ourselves for securing the data and information. Cloud is another increasing factor. It's about 1 trillion is the market size to in 2026 expected, and almost 67% of the, even maybe more. So all enterprises are today moved to cloud. It's about $600 billion worth of public cloud market as of today. The cybercrime is increasing. It's about $17.6 trillion market expected by 2025, which is much bigger than any of the majority of the economies such as India, which is only about $3-4 trillion. 80% of all data breaches are PII data, 71% of breaches are financially motivated. 8 trillion is lost in all reported breaches in 2023 itself. The FBI's statement of internet crime report revealed that there are what 800 or 1,000 cybercrime complaints. And if you see the same similar FBI and IMF report, see the market size since 2018 from less than 1 trillion is going up to 24-25 trillion dollars by 2027. So in the year 2023 is estimated to be about $11.5 trillion, which is much bigger than any small economy or even bigger economy. Today, India is the fifth largest economy in the world, and we are about $3-4 trillion, and the cybercrime is still bigger than that. So why I'm saying privacy is not an easy subject, it's difficult to achieve. We have been having discussions on this in several WhatsApp groups and other forums. And I would like to emphasize once again why privacy is not easy as cybersecurity also. Cybersecurity is comparatively easy. Privacy is more difficult. It is reflecting from this slide. Majority of these companies who are paid hefty privacy fines in billions and millions have access to a lot of resources in terms of manpower, in terms of capital, in terms of working capital, in terms of billions and millions of dollars that they transact. Now, despite having the entire team of legal, technical, compliance, and the financial bandwidth, they are still not able to get privacy right. Right? Another point I'm trying to state is GDPR was effective in 2018, May 2018. Until date, about more than 5 years of GDPR into existing. Some of the data show that less than 50% companies are still not compliant with GDPR itself in Europe. I'm not talking about other countries or places. So the emphasis here, and why I said about we are a cybersecurity firm and not a certification firm, because a lot of certification companies tend to say, okay, privacy can be audited in 3 days, 4 days, and 30% of the ISMS time. And I totally do not buy that argument from them. Honestly, from the sheer size of this slide and the kind of hefty fines people have paid, it is very evident that privacy is not an easy subject. It is difficult to achieve, and you will have to devote a lot of time and efforts to come to these terms with the DPDP Act. It is said easy. People say ISO certification can be done, 27701 certification is easy and people can comply. No. No. You will have to spend a lot of time and effort in complying with privacy. So the last 4 years, we have got more than, I don't want to give a number, but we have got several of those companies, our clients, who have signed up with us for privacy, and they have taken at least 2 years or more to comply with the basic fundamentals of privacy. Why? We will come and see what is required to do that and why it takes time. So now let's look at some of the highlights of the DPDP Act. The context is India wants to reach to 5 trillion economy now, immediately, as soon as possible, and then to a 26 trillion by next 25 years. That was why it seems that the government of India wanted a platform to have compliance with everybody and to have a platform so that everybody can expand within the framework of the regulation. It all started in 2017 when Supreme Court passed a judgment, Puthuswamy's judgment, that privacy is a fundamental right. And then we have seen various steps for the last 5-6 years. Sri Krishna Committee was formed, and the PDP bill was there, which was later withdrawn in 2022. And the DPDP bill was presented, which got passed on August 11, 2023, and it's become a law as of today. So finally, we have the act, we have the law, which says that data in digital form and any data in non-digital form which was digitized subsequently. So the act covers two major aspects: the digital format data and non-digital format converted into digital. It is applicable outside the territory of India also if the processing happens like this. That's what it says. Now, if we compare this with the GDPR and the ISO 27701, which is our primary discussion today of how to comply using 27701. We are just comparing the terminologies. The DPDP Act introduces the terminology of data fiduciary, which in GDPR terms resonates to a data controller, and even the ISO 27701 terms it as a controller. Data processor is the same, data principal is the same for ISO, but GDPR calls it as a data subject. We are calling the Data Protection Board, and GDPR calls it supervisory authority. ISO is not a law, so it's only a standard. So there is no data protection board or anything. It's the company who's everything into that. So data protection officer is what the act says. GDPR also says the same thing. Consent manager is a new topic here in Indian context, and we will talk about that. And we also have a significant data fiduciary, and which also is a controller in a way. There are definitions which I'm not going through all of them because we have lots to discuss on more important aspects. But these are the definitions that the Act gives about personal data, digital personal data, data principal, data fiduciary. Data fiduciary, we said, is the controller, the person who, alone or in conjunction with other persons, determines the purpose and the means of processing personal data. That's what it is. Processor is any person who will process the data for the fiduciary or for anybody else. And there's a significant data fiduciary is important to understand that any important which will be notified by central government under section 10. So that's important. So personal data breach is any unauthorized processing is the breach. Consent manager is a person registered with the board who acts as a single point of contact. Processing means we are actually dealing with the data. We are collecting the data, recording the data, storing the data. Everything it means is processing. Specified purpose means specified legal purpose under the Act. There are a few principles under which, when the bill was presented, these were the principles behind the new DPDP bill at that time. It said that it wanted to do lawful processing, it wanted to do purpose limitation, data minimization, accuracy, storage limitation, reasonable safeguards, and accountability. These are the principles on which the draft bill, when it was presented, was made. Now, the Act also introduces some rights of data principals, which are right to access their personal data, right to correction, right to erasure, right to grievance, and right to nominate. Along with the rights, we also have duties of the data principals, which means that they need to comply with all the laws. They provide authentic and correct information, and they also need to, abide by the regulations by not impersonating, by not hiding and omitting, and not registering any false grievances against the board or against the data fiduciary or anybody else. So the consent for data collection is one of the primary aspects. It talks about the consent given by the data principal shall be free, specific, informed, unconditional, and unambiguous, with clear affirmative action and as is necessary for each specified purpose. This is the most important thing. And if there's a child or a disabled person, they will need a consent. And government can exempt any agencies from the act. And of course, there are exceptions in case of medical. There are restrictions. Currently, the restrictions, it says it will be notified, but the act does not restrict per se as of now that you cannot transfer here or there, but they say they will be notifying. So that's the restriction as of now, that it will notify. So data fiduciary use a data controller also in terms of GDPR and in terms of the ISO. So they can process for lawful reasons personal data after obtaining the specific consent. GDPR calls it explicit consent. Here we are talking of specific, unambiguous, and specific consent. We need to implement safeguards. Data fiduciary will need to implement safeguards. They will need to be accountable. They will need to retain data limitation as per the consent. They will have to only collect minimal data as required for specific purposes. If you have seen the act and read the act itself gives examples of some cases, use cases where what data would be required in a specific use case. So data protection board, it's talking about that they will be able to, hear and provide for remedial actions before they can be appealed in the appellate tribunal. The guardian and consent we just discussed. Then we also say that they also say that data processing should also comply with the act, and of course there should be a grievance address system by the data fiduciary. So this is what is the highlights. Now, significant data fiduciary is an important aspect because government, they say they may recognize bigger companies as significant data fiduciaries, which will have more responsibilities, and that will be based on the volume of data they process and the risk of harm of the data principle, potential impact on the integrity of India, risk to electoral democracy, security of the state, and public order. So they can define any entity or any platform as a significant data fiduciary. That's the power the government has. For a significant data fiduciary, they will have to appoint a data protection officer who would be based in India. That would be the point of focus for grievance addressal system. They will need to appoint an independent data auditor. That's important, and that's why we as certain empaneled firms come into business. You will have to appoint an independent data auditor, and I believe that would be somebody from certain empaneled. They will also need to do a data privacy impact or data protection impact assessment, DPIA, and periodic audits, which we will discuss in the later slides also. So our minister in a question addressed this point of would the Ministry of Home Affairs and the national investigation agencies, which have a lot of sensitive data with them, would be considered as significant data fiduciaries also. And to that, he answered, it's a yes. He says government institutions, big or small, will be classified as significant data fiduciaries. That was the answer, and I have just copy pasted the response from the medias. That's what is stated in this. Now it also talks about Data Protection Board of India, which will be established for addressing grievances from the data principal by the data fiduciary. If not, the Data Protection Board will come on light and arbitrate the matter or whatever the process is defined. The appeals against the board can be done against the in the appellate tribunal within 60 days time, and they said they to try to resolve in 6 months of time. Okay, there would be alternative dispute resolutions that will be defined by the board or under the act. Now the important factors here, most important, breaches. If there is a breach, right, the penalties can extend up to 250 crores for a single instance, and so on. right? So this is an important that we need to bear in mind, that companies will have to bear penalties if there is a data fiduciary breach by data fiduciary, and the board will take a decision on what is the extent of penalty based on the circumstance. There's another important statement by the minister, is the era of misuse of data. Selling, buying, and misuse of data. We all get in India calls from housing finance companies, personal loans, auto loans, and several other calls. It says the era of data misuse is over. That's what the minister says. And it says in case of a data breach, citizens simply need to visit the websites and provide the data protection board with details, and the board will initiate an inquiry against the data fiduciary or the platforms, whatever the case may be. This is a statement, it's not my interpretation, it is what the minister said. So now let's see what the DPDP Act talks in terms of safeguards and implementation of controls, and how the ISO 27701 is relevant to that fact. Now, Act says that we need to implement security safeguards, such as the control would say to encrypt encryption as one of the items to anonymize data or to de-anonymize data. Just to give you a more clarity, that our data breach can be reduced, the impact of a data breach can be reduced if the data is anonymous. That is across most of the laws, most of the requirements in the laws across the globe. If the data is non-anonymized, like means the name, email ID, or any personal information is not visible to anybody, okay, just an age or just what he bought, right? Only that is available. It doesn't reflect to any specific individual. That is anonymized data, right? So anonymization and de-anonymization is an important aspect that people who want to implement the controls for compliance within the Act will have to understand in the depth, look at mechanisms to do that. So for data breach happens and the data is anonymized data, so there's no penalty can be levied because it cannot be directly reflected to any specific individual. So the data is anonymized data. So that is what GDPR and many other acts provide, and I believe that would be the same for the DPDP Act also. However, that is not an easy topic and it's not an easy subject, and that is the reason the complexity of complying with privacy comes in, because in security you look at other layers such as application and infrastructure and all. Here you're going at the metadata level to see what rows and columns have data and what needs to be encrypted or anonymized or de-anonymized as per the use case and as per specific access required to that relevant data at during transactional time or during any other time until the data is with us as a data fiduciary. And that is where the complexity in privacy starts, right? If you're an application owner or you are the controller or data fiduciary, you are keeping the data with you. That's where the complexity starts, and that is why it becomes more difficult than even security to do compliance on privacy. And that's what ISO 27701 talks about: privacy by design and privacy by default. That is what you need to do. You need to look at what are the data elements in terms of metadata you are collecting. What is the is data minimized? Have you collected only the relevant data? What databases you have? What database tables you have? Where is the storage? Is it flat files? Is it SharePoints? Is it file folders? It is databases and all across your entire layers in the IT, including emails, including personal laptops, including kiosks, and so on, right? So you will have to do an end-to-end data lifecycle management across all the touch points that we have, and that is where the complexity increases. In a recent event at Data Security Council of India, I was talking to some of those guys, and I was talking about why, since we know that the data protection bill is already in place, have we made some some roadmaps as to how are we going to comply with it. Because what I understood is people are only trying to understand what is privacy and that what is at a high level what the act says and everything. So in my thought that we Indians, many of us, we Indians are reactive and we are not proactive. I would rather request everybody to be proactive, specifically in privacy, because it is not an easy subject. You're going to take time to implement all those privacy by design principles. If you don't look at privacy from a design and privacy as a default perspective, you will not be able to comply with this act. Not only this act, any act across the world when it talks about privacy. Whether it's GDPR or it's US New York Privacy Act or California Privacy Act or Colorado Privacy Act or across the world, this is a framework which helps you to comply with majority of the acts, not just the DPDP Act. So if one implementation of the 27701 framework will help you comply with multiple laws across the globe, at least majority of 70 to 80% of these requirements, then you'll need to specifically tweak about the specific requirements for each act, which is not a major factor. Once you do a privacy by design and privacy by default structured approach into your organization, right, you will be able to comply with most of the requirements, because all of these, not all, majority of these acts, I would say, are based on those 8 to 10 privacy by privacy principles, which is generally accepted privacy principles, which was made by AICP and CICA of Canada. So most of them are derived from those privacy principles. And if you get those principles right, you will be able to comply with everything. Now coming to grievance addressing system, it talks about we just discussed the 27701 talks about having a mechanism to object to PII processing and so on. When we're talking of personal data of children, also the 27701 talks about collection of conditions for collection of processing. DPO also talks about the specific context of the organization, how the organization is going to address the privacy issues, which the DPO is the point of focus should be there. Now, specifically, the Act requires, we just saw that we're talking of specifically for significant data fiduciaries, we're talking of DPIA, and they will need to conduct periodic DPIAs. 27701, the PIMS talks about doing a privacy impact assessment, which is something similar. Now, the data processor is the same we just discussed. Limitation we talked about just now, and 27701 also talks about limitation of processing. When talking about transparency, we're talking of 27701 talks about recording related to privacy PII based on the governing principles of PII itself. Now, talking of responsibilities of data fiduciaries, the PIMS talks about conditions for collecting of processing itself, right? Accountability, and the PIMS also talks about the PII conditions and collection of processing, which is the accountability itself. Now, doing audits. We just saw that significant data fiduciary will need to do periodic audits, and PIMS as a standard itself needs yearly audits as part of initial audits and surveillance audits for compliance. Besides that, it also talks about legal audits and legal compliance and legal validation from the lawyers of the company itself on a periodic basis, and a declaration that you comply with all the acts. Even the 27701 talks about those aspects clearly. Now, auditing policies is also covered. Consent, we all just discussed. We need to have a specific consent, explicit consent, whatever we talk, but we need a very purposeful consent for that specific activity that we are going to do, and that is very, very clear across majority of the standards, including the DPDP Act. Cross-border transfer we just discussed. The PIMS also talks about jurisdictions and restrictions for transfer. Consent is what is a continuation, and rights we just discussed. Rights and obligations is also covered under part of PIMS. Limitation is also covered. Notice is covered as part of the conditions of collection of processing. Restrictions we already discussed. Limitation, storage limitation, data minimization, all of those will come under restrictions. And also it talks about how long we can talk. Storage limitation, retention, this means the same thing. Withdrawal of consent, the Act talks about. The PIMS also talks about providing a mechanism to modifying and withdrawing the consent. Now we'll look at some of the other areas how PIMS can be useful. So PIMS is a important framework which is based on the ISO 27701. The most updated standard on that is 2022. However, 2013 is still there. Many companies are still using 2013. But this, when it was brought out in 2019, the PIMS standard, it was directly aligned to the 2013 standard. And you'll see some of those slides that we have are still mapping to them because it's more easier for us to map to 2013 despite the 2022 Act also coming. But more or less, if you see, the controls are similar. So the PIMS assures that data subjects and customers are managed responsibility. It will integrate with the 27001, which is ISMS. It will provide clear visibility to data management approaches and partners. It will help to achieve compliance. Yes, this is important. Just because you have implemented PIMS does not necessarily mean that you are compliant. If you do not implement the controls in its true spirit, you will never ever be compliant. There are certification agencies which sell certificates. If you just buy certificates and do not implement in the core aspect of it, right, in the true spirit of it, you will never ever be able to comply with either DPDP or any privacy acts or even cybersecurity compliances for data breaches. You will never be able to do that. So it will help you provided you implement in the true spirit of the requirement of the control. Right? It indicates that assurance can be managed without infringing data subjects' rights. Yes, this is what the framework talks. This is another highlights. It talks about information security, operations management, physical security, access control, HR, acceptable use, asset management, and so on. It is mapped to other ISO standards compliant with GDPR. Other standards 27001 establishes a framework and of course aligns to the guidelines of the ISMS, which is 27002 also. Again, it talks about the alignment to different laws and the frameworks for ISO and other this thing, which I will just quickly skip this. Now, if you look at the general framework, it talks about the same ISMS principles of the clauses, first from 4 to 10, which is the same as per ISMS. Then it talks about the annex controls from other asset management, information security policies, and so on, which is same to ISMS. I'm going to focus only on specific areas. I'm just glancing through this because of paucity of time. Then I will directly come to the requirements for Clause 7 guidance for PII controllers, which is directly relevant to privacy. Now, PII controller, as we have seen, is a data fiduciary under the DPDP Act. Right? Now, if you look at Clause 7.2, it talks about conditions for collection and processing, identify and documented purpose, identify lawful basis, which DPDP Act also says it should be like lawful basis, determine when and how the consent is to be obtained. The DPDP Act also says the same thing. Obtain and record the consent, the Act says the same thing. Do a privacy impact assessment, the Act says the same thing. Contact with PII processors, that's what it says. We have joint PII controller, that's fine. That's how you have a mechanism, whatever you do that. Records relating to processing of PII. Now, if you see all of these areas, right, they are directly or indirectly taking you towards the direction of complying with the DPDP Act, right? There could be specific 1 or 2 steps which we'll need to look at from a point to point, but on the face of it, it would meet majority of the requirement. Now, if you see 7.3.4, it says providing mechanism to modify or withdraw consent, which is the rights of a data principle that we just saw, right? Access and correction to Azure, PII controller's obligation to inform third parties, providing copy of PII processed, handling request, automated decision making. So all of these have already been made easy by the framework itself for you to adopt and implement, right? That is what we are trying to communicate to you. Now, 7.4 talks about limit collection, limit processing, accuracy and quality, PII minimization objectives, de-identification, temporary files, retention, disposal. Then we're talking of identified basis of transfer between jurisdictions, cross-border transfer, countries with international organizations with PI can be transferred, record of transfer, keep records of where you've transferred, record of disclosure to third parties, keep records of all disclosure to third parties, right? Now, there's an implementation guidance also provided under the A 7.4.4, which is limit collection control. You should limit the collection, limit processing, accuracy and quality. This is, we have just seen these requirements, and these are the guidances provided under the PIMS framework itself, right? How do we do that? Now, if you look at other 7 point temporary files, retention, disposal, we just saw all of this once again, glancing through it, right? Now, again, it also gives a guidance for processes. Now, the DPDP Act allows us to give the data to third party for processing, provided the data fiduciary takes the responsibility of it, right? Now, when you do the processing from a third party, right? Do we have a customer agreement? Do we have the purposes for what the transfer is getting made? Do we have restrictions on marketing and use? Do we have infringing instructions? Do we have contracted customer obligations? Do we have a record of what is being processed? Do we have contractual clauses of the obligation to PIA principles, temporary files? When you are doing a third-party data processing, we need to look at all of these aspects as part of the contracts, as part of the audits, as part of the processes that they have in depth. Not just, okay, they have our 27,001 and we rely on it and we give the data for processing for third parties. That will not just be sufficient. You will have to audit your third party processors as a data fiduciary and make sure that all of these steps are being done, and not just rely on their 27001 certificate. You will not be relieved from your obligation just because you are relied on the 27001 certificate of that third party. That is my interpretation. The legal teams can, of course, be consulted, but as far as I understand, the data fiduciary's responsibility is to look at everything, and they are responsible even for their processes, as far as I understand from the Act. Now, the annexures A2F also talks about control objectives for controllers, processes, mapping to different ISO standards, mapping to GDPR, mapping to other ISO standards, as such. The ISO IEC 29134/2017 also gives guidelines on how to do a privacy impact assessment, right? We'll also see how NIST can also be used in the next slides, but this is also the guideline to do a privacy impact assessment, which is a mandatory thing for the significant data fiduciaries to be doing for complying with the Act, right? Now, if you look at the PDCA principle, we always do a plan, do, check, and act, which is also the 2701 or the PIMS talks specifically of privacy by design, privacy by default, which resonates to the same thing. Now, we just discussed this. Since the DPIE will need to do a privacy impact assessment, right? They can use the privacy framework to do this. But before you go into the framework, it is important to have a data governance system in place. You need to list down what all data sets you have, what are the databases you have, what is the data, metadata in each of those databases, what are the aspects of the data that you're collecting, data keys, what you call it, self-asserted, driver's license number, or date of birth, legal name, name, address, token identification, transactional information, username, passwords. What are the things you are storing in your database? How they can be anonymized, how they can be de-anonymized across the entire data life cycle. What is the retention period for each and every data set that you are going to take or collect or you already have? You will need to go back to your drawing board, back to your architecture of the entire data flow. You need to have data flow for each and every data sets, and this is a sample provided by NIST. How you collect the data from the data platforms, from social media, from your transactional data, from your accounting systems, from your payroll systems, from your third parties, etc., etc. Where do you store? How do you store? Where is it being stored? In the cloud storage, into your NAS storage, into your government storage, and whatever areas. You'll have to create an entire data governance framework and the data life cycle for each data set to be compliant with DPDP Act or any of the privacy mandates. And that is where the complexity increases. And that's why, in my opinion, it is not, if you do an ISMS and you have X number of days for an audit, right? And to comply in-house, I wouldn't take 30% of the time which many certification bodies I understand take. In my opinion, it is not relevant because the complexity of every environment is different. It will go on the basis of number of applications, number of databases, number of data governance systems they have in place, and it will be calculated based on how many applications they own, what is the size and the complexity of the databases per se. Privacy cannot be done by 30% of ISMS time. Period. If anybody is doing it, then they don't understand privacy. And that is very clear from the hefty fines that all the big names that we have seen earlier in the slides, you name Facebook and so on, into millions and billions of dollars, because you are to go back to your architectural platform to do privacy compliance. And that is the reason we recommend using frameworks such as PIMS in terms of overall governance. You can use any other framework, but we recommend PIMS because PIMS is well structured for privacy. You can use this privacy framework to do privacy impact assessment or other areas which talks about identifying, governing, controlling, communicating, protecting, and so on. So these frameworks are for free. This is available for free. You can use it. You don't have to pay for it, right? Use those frameworks to be better compliant with those requirements of the DPDP Act. The next we just saw talked about identifying the problem, doing a gap assessment, doing a governance, doing a controls, what we need to control, doing communications of who is going to do what, and so on, and how do we protect and how do we implement those controls, anonymization, de-anonymization, and so on. So quickly, we have 2-3 minutes for the using to see what are the benefits of using the framework to comply with DPDP Act, right? Again, to summarize, I would recommend to follow an established privacy management system. PIMS is that you can follow the structured methodology, you can fine tune that, cover whatever is required of the PIMS. If you have additional requirements from any specific act, DPDP Act or anything, add that into the process. It does not stop you from adding anything more. The minimum requirement of the framework should cover majority of the requirements, but when we do a specific compliance to your specific environment, we can add every specific aspect of any act that is applicable to you. Right? You can do that in-house. It will help you provide assurance to third party. Yes, provided it's done in the true spirit. It will help you demonstrating compliance. Yes, it will help internal, external auditors and other stakeholders to understand your status of where you are in terms of the DPDP Act compliance or any other requirements. It's an add-on to an established framework, ISO 2001, but don't go by the face of it. It is more complex than 27001. Take my word, I know that many of our clients, they have taken 2-3 years to implement the privacy, and this is, I'm talking from practical 20 years of cybersecurity experience. Don't go by just what certification bodies will tell you. In 5 days we will audit, in 7 days we will audit. They will not be able to do it. If you want to take any auditor, take their interview first. Who's actually going to audit? Understand their depth of the subject before you sign up with anybody. Don't go with the names. Many of the names are good on the face of it, but when you come to practical aspects, they don't deliver the right requirement specifically for privacy. It's a complex subject, and of course 27701 aligns with other frameworks such as GDPR, etc., etc. So one important aspect, the last point here is identify, prioritize, manage risk throughout data lifecycle, which is one of the most important aspects which we discussed in the earlier slides here. Yeah, data lifecycle. Create a data flow diagram for all your data sets, which is without this, you will not be able to comply with privacy. Again, finally, I'm telling you, privacy is more complex than cybersecurity. Hence, start your journey today to comply with the DPDP Act or any other privacy act that you are liable to comply with. Finally, we'll do a disclaimer that whatever I said was a personal opinion. Do not take it for granted. may or may not be applicable to your specific environment. If you need specific advice, what will be applicable to you, please reach out to us. Our email ID is provided, info@sej.io. Reach out to us and perhaps we may be able to help you out. Thank you, and we'll take the questions now.
Great, thank you. So I have started the poll, and I would request everybody if you can please participate in our poll. And simultaneously, we are also open for questions. So we already have a few questions. I will just address the first one, that will this be recorded? So yes, this entire session is recorded and everybody will be getting a link for this webinar recording. Sir, if you can address the other question.
So there's a long question. I suggest you to email it to us and we can take it offline, because to understand the question will take time. It's a short question, we can do that. But you're giving a specific use case, and to understand the use case, I'll have to give an answer based on that specific use case. You send us an email, let's have that question answer one-to-one. So the next question is, does the data principal have the right to withdraw consent? Of course, we just discussed that. We just saw in a slide, right? The Act provides a data principal to have the right to withdraw. Absolutely. The Act provides, the PIMS also provides the user, it's a user's data. But you should be understand that if you have given a consent, lawful consent, you contracted, let's say you contracted with the ABC bank to take a home loan, right? You have given a consent to use the data only for home loan. Now, you may have contractual obligations until the period of the home loan to keep the data with them, right? You can give a consent, specific consent to, okay, that consent to be used only for the home loan purposes. If you given a consent for some other purposes, yes, you can withdraw. But if you're given a consent for home loan purposes and they have to communicate to you for that specific purposes, I don't know how you can withdraw that consent, right? So we'll need to look at a specific use case to see how it's possible or not possible. But the Act provides, and you should be able to do that as long as it's lawfully provided. What are the opportunities for Indian IT companies DPDP space? I don't know, because it's a vague question. It's open-ended question. Opportunities in what aspect? Now, opportunities, I would say there are more responsibilities in the DPDP space. They have to comply with all those acts. Along with responsibilities, there could be opportunities, but let's discuss it on a one-to-one basis. Next question is, where is there in the DPDP which is not covered under 27701? So let me answer this at a holistic level. 27701 is not a law. It is a framework that will help you comply with the law. The framework can be customized, can be adapted, can be modified to comply with any specific law. We are not comparing two laws. We are comparing a framework which can be used to implement all your controls and add any specific controls as required by DPDP or GDP or any other act to help you comply with those laws. I hope that is very clear now. Now, will fintech firms and banks be categorized as significant data fiduciaries? I don't see any norm set, but the government, the bill says the government can declare anybody as a significant data fiduciaries. I would expect that majority of the banks and majority of those fintech companies would come in that category. This is my personal opinion. Let's see what happens. Next question is 27001 certification mandatory? I think I answered this question already on this. Okay. How do I inform if I'm a significant data fiduciary? How do I know? I think the government will define those industries, those categories, that you will be a significant data fiduciary or not. They will announcement will soon come. How does someone become an independent data auditor for conducting data audits, data fiduciaries? Good question. The definition of independent data auditor and what are the criterias, I didn't see them in the act, but government soon would announce that who is going to be a qualified independent auditor, and let's wait for that announcement. Who is an independent data auditor, CPA or ISO? I think I just answered that question. What is the dependency on the statement of applicability ISO, such as within ISO 27701 certificate awarded to an organization in the context of the SOA varying from company to company? I really don't understand this question, but let me try and answer this. Statement of applicability, you look at what are the specific aspects of the framework which are applicable to your environment. Now, if privacy is applicable to you, you will have to list a specific SOA for privacy 27701. Right? You will have to look at your business complexity and define whether you are a data controller or data fiduciary or a processor. And based on your basic definition of whether you're a fiduciary as in terms of DPDP or you're a controller, you'll have to define what is applicable to you. Right? If you're a controller, almost everything will be applicable because the managing of the consent and the notice to consent and all those rights of data principles that we just saw will have to be managed by you as a data fiduciary or the controller. So all those aspects will be applicable to you, and you will have to keep those check boxes on in the SOA. Now, if you are a processor, right, you may be able to eliminate some of those consent options, notice to consent, and maintaining a DPO because you are directly not responsible to answer to the data subject or the data principal in terms of DPDP Act. So some of those relevant aspects may not be applicable to you. So based on what is applicable to you, based on the context of your organization, based on the kind of data you are collecting, based on the specific activity you are doing, you will have to address that issue. I cannot answer that in the absence of the context. So email us to us or have a one-to-one call with us. Maybe we can have a one-to-one session to address your specific issues. Now, next question is, will an institute of national importance like a IIT or IIM be considered significant data fiduciary? I think the minister just answered that at a holistic level with two examples of MHA and NIA. So he said any government entity will be a significant data fiduciary. That's what I understood from the minister's statement. And let us wait and see what ultimately the announcement comes by notifications who all are significant data fiduciaries. As of now, it's anybody's guess. Your guess and my guess could be the same. Let's wait and watch. So what will be the timeline for complying with the DPDP Act? Good question. The Act does not state as of today what is the timeline, but having explained to you well what is required to comply and understanding that even in more than 5 years, people are still not able to comply with the GDPR Act. And because it goes to the data layer and the metadata layer, etc., it is complex depending on the number of applications you have, number of databases you have, and so on. You will take, I mean, if a company with so many applications, so many databases could take anything from 1 year to couple of years to comply with that act. So my suggestion would be to start as early as you can. As it should be as of yesterday, and that's what I told you. When I met people at DSCI conference, I thought people would be ready with a roadmap to implement. But what I understood, many of the Indian companies are still in a reactive mode. So when the act comes, we'll see they did not have a roadmap despite the bill being there since October, the new bill. Okay, so I thought people would have made roadmaps on compliance, but I've yet to see a company who has actually made a roadmap in terms of large data fiduciary banks, etc., to comply with the act. Next question is, can individuals directly go for 27701 certification without getting 27701 LALI? So you're talking of individuals or we are talking of companies here to be certified on 27701. Now, if you see 27701 is an add-on to 27001. it stands on top of. If you don't understand 27001, right, you will not understand 27701 also. So you need to understand security to do privacy also. And that is the reason majority of the professionals in the privacy space are from the security field, because that is the base. Right? And I would recommend to understand 27001 first before you go on to 27701. So again, it's a specific use case. Next question, please email it to me. If you're going specific use case, we'll need to look at from that perspective. Right? What are the key differences between ISO 27001 and 27701 standards? I think I covered some of those aspects in the presentation, but let me reiterate that to you. 27001 is an ISMS security framework, which talks not at the database layer, not at the metadata layer. When you do 27001, majority of the controls are the network, firewall, HR controls, and physical controls, and the controls at a higher level, and we just talk of encryption as required. When we talk of 27701, we are talking of entire data collection process in terms of consent, in terms of notice, in terms of withdrawal of those consents, which are not covered under 27001. We also talking of data anonymization, data de-anonymization, and we're talking about data lifecycle approach, retention, of course, which is in more in depth from a privacy perspective. Then security is at a holistic perspective. When you talk of security, you're talking about a holistic perspective. When you're talking of privacy, you're talking of specific database layer at the metadata layer. I hope the difference is very clear. I think these were all the questions, and I think we are just in time for close. We have a couple of 1 or 2 minutes more. If there are any specific questions, we can address them. So there's one question. Let me take this. Like we have, since we have 3 minutes, let me try and answer. So the question is: Organization A engaging 27001, certified company B engaging in certified company. Okay, B for data integrity database should look at the SOA internal controls tested, and for the excluded controls, and include balancing controls in the terms of forms of contractual obligations, internal controls while engaging the organization. So let me tell you once again, I think I covered this aspect to a certain extent. Let me reiterate. Don't rely on the certifications. Certifications are for internal. Third parties should not rely on the certifications rather than do their own audit of what is required for the specific data processing that you are giving to a third party. Engage an independent auditor, go and get themselves audited. Don't rely on SOA, don't rely on any certifications. Some of the certifications can be misleading. Okay, my advice, my opinion to every data fiduciary or significant data fiduciary is appoint an auditor, make him go and audit your data processor. See what they're doing. Don't rely on SOA, don't rely on any certificate. Rely on a competent auditor. Just take any auditor, because the stakes are very high. The fines can be 250 crores. The audit cost will not be even maybe 1% of that, maybe even less than that. Okay, you can't take a risk with the complying with the DPDP Act or any privacy act. You have seen Facebook, Google, and so many hefty penalties they've already paid. Do you want to take a chance? It's up to you. Right? With that, I think we can. I think we have done the polls.
Yes, sir.
Okay, then I think I thank everybody for taking their important time. We are such a big gathering today. That shows the importance of the act, and that shows that everybody is interested to comply with the act. If there are any specific issues, we can be reached. We can have a one-to-one meeting with your company to see how we can help you to comply with the DPDP Act. Of course, we are certain panel auditors. Auditing is our work. We also provide training. We have to PIMS training on a platform available. If anybody wants to do LA/LI training on 27001, 27701, they are available on a platform. Just sign up. It's an automated platform, and you can take the training right away. Okay, with that I end. Thank you everybody for joining, and hope we have a good luck to everybody. Share good luck to everybody to comply with the DPDP Act and any other privacy acts that you may be required to be compliant with. Thank you and have a great day. Bye.